Under God, 7th edition, updated and revised by William C. Hendricks. Chapter 12. Amendments to the Constitution. Important ideas to look for. The first 10 amendments protect the rights we have as image bearers of God. The amendments do not state all the rights that belong to the people. Some of the amendments were added to make changes in the Constitution. Amendments deal with a variety of problems faced by our nation. The Bill of Rights. Even before the Constitution was ratified, many people said that it did not protect the rights of the people well enough. They began to talk about a Bill of Rights. When the first Congress met, the senators and representatives of many states asked that amendments be made to guarantee the rights of the people. The rights they wanted were written down and organized into 10 amendments. Almost as soon as Congress proposed these amendments in 1789, the proposals were sent to the state legislatures and quickly adopted by them. In 1791, these amendments became a part of the Constitution. Shortly after Congress proposed these amendments to protect the rights of the people, North Carolina and Rhode Island, who had been waiting for such a Bill of Rights, ratified the Constitution and came under its government. The first 10 amendments protected people's rights against unfair use of power and laws by the national government. Most state constitutions also have a Bill of Rights to provide similar liberties under the state laws. Our constitutional Bill of Rights does not give rights to us. Only God, who created us, can give us the rights to life, liberty, and the pursuit of happiness. Our Bill of Rights protects the rights we have as image bearers of God. Amendment 1. Freedom of religion, speech, press, and assembly. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. It's easy to see why religious freedom was mentioned first in the Bill of Rights. Many of the first settlers had come to America to find religious freedom. Many had come from countries that had state church. By 1789, there were many different denominations in America. Although a few of the colonies had established or official churches, and people wanted to guard their freedom to obey God and their conscience as they believed was right. When the New Testament church began, it was separate from the state or government, and was often persecuted by it. Constantine had become a Christian, and in AD 313, he stopped the persecution of Christians. Theodosius, in AD 380, made the church a state church. Everyone, believer or not, had to join. Then the troubles began. The church became corrupt, and the state began persecutions of pagans in the name of the church. We may be thankful for the First Amendment prevents our government from establishing a state church, and that membership in the Christian church depends upon a love for Christ, not upon a law from Congress. This part of the Constitution, as it is now interpreted, makes it impossible to teach a religious faith in a government or public school. However, it is this very same part of the Constitution that gives parents the right to have Christian schools for their children, or abridging the freedom of speech or of the press. Congress must allow us freedom to say what we want to say and print or publish what we think. This freedom is limited by the laws of libel and slander, and by the laws of treason. Freedom of speech does not mean that a person may hire a sound truck, drive at midnight into a quiet residential district of a city, turn up the volume, and make a free speech. Nor may one use freedom of speech to turn in a false fire alarm. Freedom of speech and the press is ours under God. We must use this freedom to glorify Him and praise His name. It surely must not be used to dishonor Him. Or the right of the people peaceably to assemble. People may assemble, or meet together to talk over anything they wish. They may be society meetings in a church to study the Bible. There may be a group of men on the street corner talking about the tax laws. No policeman or other government official may come in and break up a meeting if it is peaceful and is not causing a disturbance to others. We should appreciate this freedom as well as our other freedoms, for not all of the people in the world enjoy it as we do, and to petition the government for a redress of grievances. We have the right and responsibility to ask our government to correct the things we think are wrong. We do not have to be afraid to ask our government to do this. Amendment 2. Bearing Arms. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The states may have militia or citizens trained to form an army, if needed. This amendment makes our country stronger because it gives citizens the right to defend themselves. Since the assassinations of the President John F. Kennedy, his brother Senator Robert F. Kennedy, and Dr. Martin Luther King Jr., there has been renewed concern about the misuse of firearms. We still have the right to keep firearms, but most states control this right by saying that pistols and other concealed weapons must be registered, that persons using guns for hunting must have permits, and that shotguns may not have barrels shorter than 18 inches. The right to keep firearms is often misused by criminals. Amendment 3. Quartering soldiers. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by the law. One of the reasons the colonists had rebelled was that the British soldiers stayed in the homes of the colonists without asking for permission to do so. The Third Amendment keeps our government from placing our soldiers in private homes for food and shelter except during wartime. Even then, soldiers can be quartered in the homes of our people only if our elected representatives in Congress pass a law to permit quartering. Amendment 4. Protection against search. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. British officers had often searched the homes of the colonists for smuggled goods. Now the people wanted protection against unreasonable search without a warrant. A warrant is a written statement from a judge giving an officer the right to search for a certain thing in a given place. He may neither look anywhere he wishes nor seize anything that has not been listed on the warrant beforehand. Before the judge issues the warrant, he asks the officer to take an oath giving the probable cause, or reason why this search is necessary. The freedom from search without warrant applies to one's home, place of business, garage, or vehicle. An open field or lot may be searched without a warrant. The right to own property was evident in the Old Testament when Abraham bought the cave of Machpelah in the field it was in Genesis 23:17 and 18. The right to own property was protected when God gave the 8th commandment, "You shall not steal," Exodus 20:15. In the New Testament, the right to own property was evident when Peter asked Ananias, "Didn't it belong to you before it was sold?" After it was sold, wasn't the money at your disposal? Acts 5:4. The freedom from search and seizure is based upon God's plan for the earth. Search warrants may be used and are often needed to provide justice. Amendment 5. Rights of persons. No person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising to the land or naval forces or in the militia when in actual service in time of war or public danger. The right of trial by jury was first given in the Magna Carta. The people in America wanted the same right included in the Constitution. A person who commits a capital crime may be punished with death. A criminal guilty of an infamous crime, now called a felony, may be punished with a prison sentence of more than 1 year. A person suspected of a capital crime or felony is brought before the grand jury. A judge appoints citizens for this purpose. They must listen to the evidence. If they decide that there is some worthwhile evidence against the accused person, they pass a bill of indictment. The accused is then held in prison or set free on bail until a petit or trial jury meets to try the case. If the grand jury does not indict the person, he or she is granted an acquittal and set free immediately. Members of the armed forces are tried not in a civil court but in the military court, called the court-martial. Each branch of the service has its own laws, and often the penalties given by military courts are more severe than those of civil courts. A person found guilty in a court-martial has the right to appeal to a higher court, called the United States Court of Military Appeals. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. A person can be tried only once for committing a crime, but can be placed on trial a second time if the jury did not agree the first time. Also, a person found guilty of a crime can have a second trial if new evidence is found. However, a person who is found innocent cannot be tried a second time for the same offense. Although the framers of the Constitution were probably not aware of it, this plan is similar to God's plan of justice. For since Christ died for our sins, we are not punished for them, nor shall be compelled in any criminal case to be witness against himself. If a defendant is asked a question during a trial, and the answer would be harmful to his or her case, the defendant may refuse to answer. An accused person who pleads the Fifth Amendment cannot be forced to answer a self-incriminating question. This clause, as it is interpreted today, also allows a husband and wife to refuse to testify against one another, nor be deprived of life, liberty, or property without due process of law. The Due Process of Law clause keeps the law enforcing executive department and law interpreting judicial department from doing as they please with a prisoner. All that is done by a law enforcement officer or judge in court must be done according to the procedures that have been established or laws that have been made by elected representatives of the people. Nor shall private property be taken for public use without just compensation. If the government needs land for a highway or other public use, it must pay the owner a fair price. If the owner refuses to sell, the government can use its right of eminent domain and take the land, but must still pay for it. Amendment 6. Rights of the accused. In all criminal prosecutions, the accused shall enjoy the right to a speedy public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. In England, during the 17th century, trials were often held secretly and sometimes lasted for several years before they were finally settled. The Sixth Amendment guarantees a person the right to a public trial held as soon as possible after charges have been made, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. A witness in a criminal case must testify in person, not in writing. The person being accused or the lawyer may cross-examine the witness. The government can force someone to witness in court if the testimony may help the accused person. Such a call to court is referred to as a summons. In 1964, the United States Supreme Court interpreted this part of the Constitution as meaning that the government must hire a lawyer to defend a person if he is unable to hire one. All of these rights help to provide liberty and justice for all. Amendment 7. Civil trials. In suits of common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. A civil court settles questions or disputes between two citizens. A criminal court settles questions between a citizen and the laws of the government. A jury may be used in both types of court. Right of trial by jury is important. Solomon said, "For lack of guidance, a nation falls, but many advisers make victory sure." Proverbs 11:14. In a jury trial, there is less possibility of a mistake because the common sense of many people is brought into the system of justice. Often a jury shows more mercy for the prisoner than the judge does, who spends much time working with those who break the law. We must, however, be aware that the jury system does have many weaknesses. The jury system is only as strong as the men and women who serve on juries throughout the nation. Trial by jury can make a long, drawn-out case of some act of disobedience against the law and can thus delay justice. Also, highly trained and skillful criminal lawyers can deceive the people who serve as jurors. These lawyers can then cause a jury to declare a criminal innocent even though he may be guilty. People who serve on a jury must have a high sense of justice. They must be able to distinguish between what is right and which is wrong. Unless the citizens of our nation realize that we are serving under God as they carry out their jury duties, the jury system will be of little use in providing the justice it should provide. If the members of a jury have very little honesty and can easily be persuaded by a skilled lawyer, it would be better to have the court case brought before a fair and experienced judge. The Seventh Amendment helps to draw the line between the duty of a judge and the duty of a jury. The jury must decide on questions of facts, and the judge must interpret the law as it applies to the facts. Amendment 8. Bail, fines, and other punishment. Excessive bail shall not be required. A person who is indicted by a grand jury, indicted by a grand jury, or arrested may pay bail, or a sum of money to the court, and then go free until the time of the trial. When the accused returns for the trial, the money is refunded. But if a person does not return to stand trial, the bail is forfeit and kept by the court. Bail is often forfeited by a person who is arrested for a minor offense against the law. Even if a person forfeits bail, the court still has the right to try the case. Nor excessive fines imposed. The amount of bail or fine levied may not be unreasonably high. The more serious a crime is, the higher the bail and fine usually is. But even those for serious crimes must not be excessively high, nor cruel and unusual punishments inflicted. No cruel or unusual punishments prevents the torture of prisoners, but does not prevent execution by hanging, shooting, electrocution, or death in a gas chamber. Everyone has the right to a fair trial and is protected from cruel, unusual punishments. But our government has the authority to punish those who do evil, for it does not bear the sword for nothing, Romans 13:4. Amendment 9. Rights retained by the people. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. It was possible to list in the Constitution only a few of the rights of the people. Because a right is not listed in the Constitution does not mean we do not have that right. For example, the right to take part in political campaign is not listed in the Constitution, but because it is not denied, it still belongs to the people. If all the rights of the people were listed, the Constitution would be much too long. Amendment 10. Reserved powers. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the state respectively or to the people. Rights and powers not given to the federal government or state government still belong to the people. In this plan, our government is under God, for God made humans in his own image, and the powers and rights not needed for government must continue to belong to the people themselves. Later amendments. Amendment 11. Lawsuits against states. Adopted in 1798, the judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. This amendment changes part of the Article 111, Section 2. It says that no individual may sue a state in a federal court. If a person has a case against a state, he must present it in the courts of that state under its own laws. Our national Constitution, under God, protects the rights of states as well as the rights of individuals. State governments, as well as national governments, have been established by God, and their authority comes from Him. Amendment number 12. Method of presidential elections, adopted in 1804. The electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballot the person voted for as president, and in distinct ballots the person voted for as vice president. And they shall make distinct lists of all persons voted for as president, and of all persons voted for as vice president, and for the number of votes for each, which lists they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be president, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the person having the highest number not exceeding 3 on the list of those voted for as president. The House of Representatives shall choose immediately, by ballot, the president, but in choosing the president, the votes shall be taken by states. The representation from each state having one vote, a quorum for this purpose, shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed, and if no person have a majority, then from the 2 highest numbers on the list the Senate shall choose the vice president. A quorum for the purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of vice president of the United States. The 12th Amendment is our longest one. It changes Article 2, Section 1, dealing with the way a president and vice president are to be elected. Today, the electors must still vote for 2 people. However, they must now tell which one is their choice for president and which for vice president. This helps to provide for the orderly election of our leaders. Another change deals with the matter of the vote. Before the amendment was ratified, if the vote was a tie, the House of Representatives voted for one of the 5 candidates with the greatest number of votes. Under Amendment 12, they now vote for one of 3 persons having the highest number. Also, the date for the inauguration of the president has been changed by the 20th Amendment to noon on January 12th instead of March 4th. Amendment 13. Slavery abolished, adopted in 1865. Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Government is ordained by God not only for the guidance of the rich and leading citizens, but also for the care of the minority, to protect those who cannot protect themselves. Section 2. Congress shall have power to enforce this article by appropriate legislation. The 13th Amendment was passed in 1865, shortly after the Civil War, because people weren't sure whether or not President Lincoln had power to free slaves through the Emancipation Proclamation. Although wiping away the traces of slavery as it existed in our country has been a slow process, love for our neighbors requires that we end racial discrimination. Prisoners may still be made to work as punishment for crime, but one person may not be forced to work for another in payment of debt. Amendment 14, Citizenship, adopted in 1868. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. When the Constitution was adopted, the slaves were not given citizenship. In fact, the 3/5 clause said they were not even worthy to be counted as a whole person. The 3/5 Compromise, page 48, had served its purpose when it caused the North and the South to agree at the Constitutional Convention. After the Civil War, however, the 3/5 Compromise was useless. No state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. The 14th Amendment gave citizenship to the people who had been slaves before the Civil War. It gave them the privileges of citizenship. It also gave them the responsibilities of citizenship. At first, many of them neither appreciated the privileges nor understood the responsibilities. Nor shall any state deprive any person of life, liberty, or property without the due process of law. The 5th Amendment says that the federal government may not take away your life, liberty, or property without due process of law. This amendment protects from unjust treatment by a state government not only the freed slaves, but also everyone else, nor deny to any person within its jurisdiction the equal protection of the laws. Anybody who is governed by the United States must be treated as fairly as everyone else, because we are all image bearers of God. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed, but when the right to vote at any election for the choice of electors for President and Vice President of the United States. Representatives in Congress, the executive and judicial offices of the state, of the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in a rebellion or other crime. The basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number, the male citizens 21 years of age in such state. Section 2 of this amendment changes Section 2 of Article 1. The slaves had been set free by the 13th Amendment and had been made full-fledged citizens of our country by the 14th Amendment. Now they could be counted on the same basis as everyone else when a census was taken to decide how many representatives a state would have. Because all Native Americans must pay federal income tax, they are all counted even though they may live on tax-free reservation land. They have all been counted since the 1940 census. This section also says that if a state denies voting rights to those who are eligible, its representation in Congress must be reduced in proportion to the number of citizens who are denied the right to vote. Section 3. No person shall be a senator or representative in Congress, or elector, president and vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Section 3 of the 14th Amendment deals with the serious matter of breaking an oath. Government officials who joined the Confederacy and fought against the Union after promising before God to uphold the Constitution of the United States were not allowed to hold a government office after the war. Because of this part of the 14th Amendment, the South states lost many of their political leaders after the Civil War. In 1872, Congress pardoned many of the men, and in 1898 removed this black mark from the record of the arrest. But by the time many of these men had already died, most of those who were left were too old to hold the government job. It was time to take more serious the words of President Lincoln, "with malice toward none, to bind up the nation's wounds." Section 4. The validity of the public debt of the United States, authorized by law, including debts incurred for payment or pension, and bounties for service in suppressing insurrection or rebellion, shall not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave. But all such debts, obligations, and claims shall be held illegal and void. The public debt of the United States is the responsibility of every citizen, but the government was not responsible for the debts of the Confederate States of America because the money was used by the South to rebel against the United States. The Southern states could hardly expect to be paid the money they had spent in rebellion. This amendment also provided that no one needed to pay the slave owners for the slaves who were set free. Section 5. The Congress shall have power to enforce by appropriate legislation the provision of this article. Congress may make laws to carry out the terms of this amendment. Civil rights laws that deal with radical integration have their power today because of this amendment. Although our nation under God seeks to provide equal treatment for all, human sinfulness often keeps complete equality from being put into practice. Amendment 15, right to citizens to vote, adopted in 1870. Section 1, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The requirements to vote are usually set by the states. In this amendment, the federal government tells the states that they may not keep a person from voting because of race or color, or because he was a slave. Recently, Congress had passed laws that seek to avoid racial discrimination in the voting requirements of the states. Section 2, that Congress shall have power to enforce this article by appropriate legislation. Amendment 16, income taxes, adopted 1913. The Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. An income tax law passed in 1894 was declared unconstitutional by the Supreme Court because the tax was not divided equally among the states according to the population. Before an income tax could be passed, this amendment had to be added to the Constitution. The income tax today is one of the leading sources of revenue for the operations of our federal government. Even though payroll deductions are made by most employers, each individual must personally declare his own earnings and deductions for income tax purposes. When we pledge allegiance, we promise to be loyal, faithful, and obedient to the tax laws. As well as all other laws of our land, we must be honest in paying our taxes, for the Bible says, "If you owe taxes, pay taxes," in Romans 13:7. Amendment 17. Popular election of senators, adopted in 1913. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof, for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state in the Senate, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election, as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. The framers of the Constitution, you remember, were afraid to give the common people too much power. For this reason, senators were elected by the state legislatures rather than by direct vote of the people. By 1900, the literacy rate in the United States was high, and the people wanted the right to elect their senators as they always had elected their representatives. By means of the 17th Amendment, the people received the right to vote directly for their own senators. This amendment increased the voting power of the people, but it also increases their responsibility to select good leaders who can direct our nation wisely under God. Senators, who today are elected by the people, should be expected to pay more attention to how people of the state feel about government than did the senators elected by the state legislature. Amendment 18, Prohibition of Intoxicating Liquors, adopted in 1919. The 1 year from the ratification of this article, the manufacture, sale, and transportation of intoxicating liquors within the importation thereof into, or the exportation thereof, from the United States and all territories subject to the jurisdiction thereof for beverages purchased in hereby prohibited. Section 2. The Congress and several states shall have concurrent power to enforce this article by appropriate legislation. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states as provided in the Constitution with 7 years from the date of submission hereof to the states by the Congress. The effects of alcohol on the body have been known for a long time. Ever since the days of Noah, alcohol in and of itself is not evil. It is part of God's great and good creation. However, its use, even in small amounts and in careful ways, may be habit-forming. People soon become slaves to its use. When they are under the influence of alcohol, they lose their sense of judgment, their sense of right and wrong, and the ability to think and act in appropriate ways. Because of this, people who drink alcohol often sin against God by saying and doing things they would never do if they were in full control of their minds and bodies. The people who saw alcohol as evil formed a political party called the Prohibition Party. Anti-saloon leagues were formed. Churches gave their support. Many states passed laws against alcohol. Such states were called the dry states. Even in wet states, many cities had local options that prevented the sale of liquor. When the 18th Amendment was passed, it made the entire liquor industry illegal. Enforcing this part of the Constitution was a difficult task, if not impossible one. People who were addicted to alcohol were willing to pay very high prices for it. Some people even began to drink wood alcohol and other impure substances containing alcohol because the purified type could not be obtained. These impure products often caused paralysis, blindness, even death. Smuggling and bootlegging were common. Hidden stills from the manufacture or liquor were everywhere. The federal courts were filled with lawbreakers. In 2 years, there was about 3,500 civil cases and 65,000 criminal cases in the courts. Disobedience was everywhere. Gangs grew in many cities, and gangsters fought to decide who would control the profitable illegal liquor trade. Some thoughtful people began to see that the 18th Amendment did not solve the problem of liquor evils. It only added to the problem of bootlegging gangs. Our government sought to enforce this part of the Constitution, but it was impossible to deal with all the offenses that took place. Amendment 19, Equal Suffrage. Adopted in 1920. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. The 19th Amendment is called the Equal Suffrage or Women's Suffrage Amendment. Before 1920, several states had given women the right to vote, but not until the 19th Amendment was passed did the vote become a national right. The political and social rights of women have grown under the democratic influence of Western culture. Equal voting rights for women are based upon the value of the individual, the fact that everyone, whether man or woman, is the image bearer of God. Amendment 20. Beginning of terms of office. Adopted in 1933, Section 1. The terms of the President and Vice President shall end at noon on the 20th day of January. The terms of Senators and Representatives at noon on the 3rd day of January. Of the years in which such terms would have ended in this article had not been ratified, and the terms of their successors shall then begin. When the Constitution was drawn up in 1787, communication was poor, mail was slow, roads were bad. After an election had taken place, several months were needed before counting the votes, for notifying the winners of this election, and for this moving to the Capitol to take up his work. However, several things happened to improve communication and transportation. The invention of voting machines improved ballot counting. The invention of the telephone, telegraph speed, communication, and the improvement of roads and highways made transportation to and from the capital faster and easier. Under Articles 1 and 2 of the Constitution, a president assumes office on March 4th. This amendment makes it possible for him to take office on January 20th, about 45 days sooner than before. Section 2. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day. The 20th Amendment also changes the opening date of a new Congress. Under the old plan, members of Congress elected in the November election would not take office until December 4th of the following year, almost 13 months later. During the time between these two dates, those who were not re-elected did very little. They were often called lame ducks because the power given to them by the people had been transferred to someone else who had been elected in their place. Under the 20th Amendment, a member of Congress elected in November now takes office on the following January 3rd, only about 2 months later. This is good because it allows the lame ducks to go home and gives the newly elected delegates the opportunity to put their ideas to work almost immediately. Section 3. If at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen before the time fixed from the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President shall have qualified. The Congress may the Congress may by law provide for the case wherein neither the president-elect nor a vice president-elect shall have qualified, declaring who shall then act as president, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a president or vice president shall have qualified. Section 4. The Congress may by law provide for the cause of the death of any of the persons from whom the House of Representatives may choose a president whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons from whom the Senate may choose a vice president whenever the right of choice shall have devolved upon them. The 20th Amendment also gives Congress the right to say who will be president or vice president if either or both of them should die between November election and the time they should have taken office on January 20th. Although this has never happened, the Constitution does provide for such an emergency. Section 5, Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. This amendment was ratified in 1933 and made the first term of Franklin Delano Roosevelt a little shorter than a regular presidential term. Section 6. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. A limit of 7 years was given to Congress to the states for ratification of this amendment. A time limit like this one is wise because otherwise the process of adding an amendment could stretch over a very long period. This kind of rule forces the states either to accept or reject the amendment quite soon after it is proposed by Congress. Amendment 21. Repeal of the 18th Amendment adopted in 1933, Section 1. The 18th Article of Amendment to the Constitution of the United States is hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. The 18th Amendment, which prohibited the sale, manufacture, and transportation of liquor, was repealed in 1933. The federal government would no longer try to control the use of liquor. Does that mean that you are free to use as much alcohol as you wish, whenever and wherever you wish? Not at all. First, our state and local laws still control the use of liquor through such laws as drunken driving laws, laws that forbid the sale of liquor to minors. Second, when the 18th Amendment was passed, the churches felt that the evils produced by alcohol would end. Today, many churches seek to persuade people not to drink alcoholic beverages because of the sin and sorrow that often follow. Third, and above all, each individual is under God. All people are responsible directly to God. We may not become addicted to alcohol. In writing to the Corinthian church, Paul asks, "Do you not know that your body is the temple of the Holy Spirit?" 1 Corinthians 6:19. People may not lay aside responsibility for their words and deeds by turning the controls over to liquor. When this amendment was passed in 1933, our nation was in a business depression. Our government needed all the tax money it could get. People knew that liquor taxes would bring much money into the treasury, but the millions of dollars received in liquor taxes do not cover the cost of caring for the people whose minds and bodies are impaired because of liquor. Alcoholism has become one of our society's worst problems. The 18th Amendment has been repealed, but the need for Christian citizenship has not changed. We are still under God. Section 3. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states, as provided in the Constitution, within 7 years from the date of submission hereof to the states by the Congress. Because the subject of repealing prohibition was so important, Congress felt that the people should decide the matter directly. This is the only amendment that has been added to our Constitution after being ratified by the special conventions held in each state. All our other amendments had been ratified by our state legislatures. This amendment also points out the flexibility of the Constitution, for it proves that amendments can be not only added but also repealed. Amendment 22. Presidential tenure, adopted in 1951, Section 1. No person shall be elected to the office of the President more than twice. No person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of the president more than once. But this article shall not apply to any person holding the office of president when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of president or acting as president during the term within which this article become operative from holding the office of president or acting as president during the remainder of such term. Section 2. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by the Congress. This amendment shows how a tradition or custom that people like can be made into a law. Both President Washington and President Jefferson decided not to run for a third term. They felt that 8 years were enough for any one person to direct the affairs of our nation. Other presidents followed this tradition from the days of Washington until 1940, when Franklin D. Roosevelt ran for a third term as president and was elected. 4 years later, he was re-elected to a fourth term of the office. These elections took place just before and during World War II. However, when the war was over, the people of our country decided that the two-term custom started by Washington should be made into law. Amendment 23. Presidential elections in the District of Columbia, adopted in 1961. Section 1. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors of president and vice president equal to the whole number of senators and representatives in Congress, to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purpose of the election of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of the amendment. Section 2. The Congress shall have power to enforce this article by appropriate legislation. This amendment gives the people living in Washington, D.C. the right to vote in presidential elections. They did not have this right until March 29th of 1961, when Kansas became the 38th state to ratify or approve the amendment, making it part of our national constitution. The District of Columbia may have as many electoral votes as it would have if it were a state. However, the district may not have more electors than the smallest states may have. Amendment 24. Removal of the poll tax, adopted in 1964. Section 1. The right of citizens of the United States to vote in any primary or any election for president or vice president, for electors for president or vice president, or for senators or representatives in Congress, shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. Section 2. The Congress shall have power to enforce this article by appropriate legislation. The poll tax was a tax that a person had to pay before voting. It was used in several southern states to keep black citizens from voting, since most of them were too poor to pay the tax. This amendment eliminated the poll tax as a requirement to vote for federal officials such as president, vice president, senators, and representatives and electors. Just as the 23rd Amendment extended the voting rights to the people living in the District of Columbia, so the 24th Amendment removed voting restrictions of those people who were limited by the poll tax. Both the 23rd and the 24th Amendments help our nation as, under God, it seeks to provide liberty and justice for all. Amendment 25. Presidential and Vice Presidential Disability and Succession, adopted in 1967. Section 1. In case of the removal of the President from office or his death or resignation, the Vice President shall become President. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority of both houses of Congress. Section 3. Whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Section 4. Whenever the Vice President and a majority of either the principal officers or the executive departments or of such other body as Congress may by law provide transmit to the President pro tempore of the Senate or the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives has written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers or the executive department, or of such other body as Congress may by law provide, transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon Congress shall decide the issue, assembling within 48 hours of that purpose, if not in session, in the Congress within 21 days after receipt of the later written declaration, or, if Congress is not in session, within 21 days after Congress is required to assemble, determining by 2/3 vote of both Houses that the President is unable to discharge the powers of duty and his office. The Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. This amendment tries to provide a better answer to the question of who is to govern the nation when the President is unable to do so because of illness or some other reason. President Eisenhower suffered a severe heart attack while in office, and that caused the nation to think about the problem of who takes over until the President is well again. Then immediately following the assassination of President John F. Kennedy, Lyndon Johnson became president, and for a while the nation was without a vice president. This amendment, like fire insurance, is something we hope will never be needed. In a responsible way, our nation's leaders have tried to anticipate emergencies and provide for them. Amendment 26, lowering the voting age to 18, adopted in 1971. Section 1. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state on account of age. Section 2. The Congress shall have power to enforce this article by appropriate legislation. In brief language, this amendment extends the privilege of voting in federal election to young people between the ages of 18 and 21, assuming other eligibility requirements have been met. Following the adoption of this amendment, many states changed their voting age requirements to coincide with those of the federal government. Amendment 27, Congressional Pay, adopted in 1992. No law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. The 27th Amendment keeps members of Congress from giving themselves pay raises shortly after they are elected. It was originally proposed by James Madison and approved by Congress in 1798 to become a part of the Constitution. 3/4 of the states needed to ratify it, and on May 7th of 1992, Michigan became the 38th state to do so, and Amendment 27 became a part of our federal Constitution. Our Constitution has been amended 27 times. More amendments may be added whenever they need arise. This is our Constitution. It is the basic set of rules that tells us how our republic must be governed. When we pledge our allegiance to the flag of the United States of America and to the republic for which it stands, we promise to obey these laws. We pledge our loyalty and faithfulness to our nation under God.